I bring you greetings on behalf of the Director General of the Organization of the Eastern Caribbean States, Dr. Didicus Jules, who was unable to be here today because of prior commitments. And we wish to take this opportunity to make some brief remarks about competition law and policy and what we have been doing at the OECS Commission in relation to this emerging area of the law. The OECS has been assiduously working towards the establishment of a competition authority to regulate competition in its member states. This initiative arises from a confluence of needs and obligations. Among these obligations is the one which arises under the revised Treaty of Chaguaramas, that member states must enact laws which effectively address restrictions on competition and establish national competition regimes. Within CARICOM, it was agreed that OECS would establish a single competition authority to serve as the national authority for all OECS member states, thereby permitting the region to pool its human and financial resources and manage more effectively the creation of a culture of competition in the OECS. To date, none of the OECS member states has a functioning competition regime. Current realities include the relative lack of competitive pressures resulting from the economic attributes of small economies, the newness of competition law in most states of this region, the absence of empirical evidence of anti-competitive conduct, and a range of constraints to the enforcement of competition law. Competition law, however, regulates business practices and transactions that create or abuse market power and interfere with the free play of market forces. A common competition policy that supports the creation of a common market is envisaged within the protocol of the Eastern Caribbean Economic Union. In general, competition rules are premised on an assumption that in a competitive environment, resources are more efficiently allocated, higher quality products are produced, better quality services are provided, and products and services are sold at competitive prices which benefit the consumer. There is currently a lack of competition culture in the member states, with member states placing much more emphasis on consumer protection issues. However, competition among vendors and service providers is also a consumer protection issue, as fostering competition among businesses will result in many benefits to the consumer. At the moment, since there is no competent authority in the member states to regulate competition and enforce competition rules, we have had to rely on moral suasion in some instances, which have not worked as well as we would have hoped. There are regulators in sectors such as telecommunications and banking, which include elements of competition in their remit. However, these do not address the wider competition issues. In 2008, OECS member states accepted a draft agreement and a model competition bill to support the realization of member states' obligations set out in Chapter 8 of the revised Treaty of Chaguaramas. The legislation is based on the CARICOM model, but further reflects lessons learned from the Jamaica Fair Trading Commission, a representative who is here with us today at the advanced training of enforcement officers. These experiences have been incorporated into the bill, as well as provisions on mergers and acquisitions. Financing for competition was allocated under the 10th EDF project in 2012, and work then recommenced with a review of the draft agreement and model bill, as well as the design of a structure and budget for the first 5 years of the Commission's operations. These have been submitted to the OECS Authority, having been recommended by the OECS Commission after endorsement by legal officials of member states, as well as broad-based validation group comprising public and private sector officials, academia, the media, and the OECS commissioners. The authority raised the question of sustainability of the Competition Commission after the 10th EDF funds have been expended, and so they requested the Commission to revise the initial proposal. The OECS Authority, during its 60th meeting in February 2015, specifically requested that the CARICOM Secretariat and OECS Commission give consideration to whether the CARICOM Competition Commission could execute the functions proposed for the Eastern Caribbean Competition Commission. Consequent on this mandate, a submission was made to the second meeting of the reconvened task force on implementation of the revised Treaty of Chaguaramas, Competition Law and Policy, in Barbados on March 19th to 20th, 2015. That meeting agreed to convene a subcommittee to address the matter of non-implementation of competition policy by certain CARICOM member states, which includes the OECS, the entire OECS. The meeting was convened in November 2015 to strategize on the way forward. Coming out of that exercise was a re-examination of the structure, the administrative needs, and the regulatory framework for the proposed competition authority. The results of that re-examination is a proposal for 2 options for the competition authority, the second of which has since been approved by the OECS commissioners and which will be presented to the OECS authority for approval. Since it has not been approved by the OECS authority as yet, I would not be able to disclose the details. However, alongside this review of the agreement and the bill to facilitate the new structure, as well as to fill any gaps that have since been identified in the model law, as well as the signed competition agreement, with the assistance of such persons as Dr. Timoon Stewart and Professor Frederick Jenny, who we have this week and last week, helping us get more training, advanced training on competition. Well, last week has been challenging for us as competition officers. This week we're going to learn to do market studies, and as you can imagine, for persons like myself, I'm a lawyer by profession, didn't like maths at all, so it's been a very challenging 7 days and beyond. But we are making it because we have a goal in mind to set up the competition authority by the end of this year. So we are stretching for that goal, and we're hoping to have you along when we do implement the competition authority. A competition regime is significant for the OECS at this juncture, as the OECS seeks to deepen integration through the economic union and to stimulate economic growth and development. The efficient and effective functioning of business enterprise and the increased competitiveness of the region are paramount. The role of competition rules in creating an enabling environment for business was taken into account by OECS member states when they constructed the revised Treaty of Bastille. Hence, the agreement to include the development of a common competition policy and joint regulatory authority among the activities to be undertaken for the purposes of the economic union was foremost in mind when drafting the revised Treaty of Bastille. In 2015, the OECS region saw the merger of Flow and Lime. The regulator was effectively without teeth to intervene in this commercial transaction. As a result, the merger between the two companies occurred. Shortly after, consumers saw a rise in prices for cable services in spite of a purported agreement with governments that there would be no increases, as was reported in the media. At this stage, there is still confusion among consumers regarding which company they are transacting business with. It appears as if there will be future acquisitions in this sector with the entrance of another telecommunications provider. Without the legal reforms, it will be difficult for the relevant authorities to effectively address these issues. The implications of a lack of competition rules and culture are evident and drives home the point that there is an urgent need to put these rules in place. As part of the work being undertaken is the training of personnel in enforcement of competition law and policy. And simultaneously with this training of enforcement officers of the member states of the OECS is this training for appeal court judges and high court judges, as well as other court officials. This training is therefore timely and significant and will build and enhance the capacity of the OECS judiciary to enforce competition law and policy on other related matters, such as consumer protection. The OECS wishes to take this opportunity to thank the Judicial Education Institute for partnering with us in this initiative, as well as the European Union for the funding received through the 10th EDF support to the OECS economic and regional integration. Thank you.